Well, good afternoon, Alex Woods here. Now this is a growing issue for people, partly because of the cost of instructing lawyers, partly of course because the small claims track limit has gone up from 5 to 10,000. So as there's a wider range of claims that are likely to be suitable for the small claims track. Now look, you don't need to instruct a lawyer at all to go to court. But there is a specific facility, if you like, that enables people who in small value, lowish value claims to get access to justice, and in that type of claim, in that what's called that track, is there aren't the strict rules of evidence that usually apply elsewhere. Specifically, lawyers are excluded because your legal fee won't be paid win or lose in the small claims track. So it is a way of handling low value disputes. But many people will be thinking, well, really, should I bother at all? Because going to court is a time-consuming, expensive, and at times emotionally draining experience. And shouldn't I be getting on with other areas of my life and putting it down to experience? Well, I think the answer to that is, at least once in your life, you're going to find yourself in a position where you may well have to stand up and, stand up for your rights. But I think the important thing is to see it more as an entrepreneurial endeavour rather than a grudge war with an opponent that you don't like very much. So I'm going to use this video to deal with some key issues that you might come across if you bring a claim through the courts, and specifically through the small claims track that I've talked about. But I'm not going to go into the detail of what's involved in bringing your small claim. And for that, you can simply look below. There's a plethora of sites that will assist you on a step-by-step basis with your claim, so go and look at those. Now there's also court forms. I mean, the internet is well populated with guides on how to do all of this, and I've put the ones that I could find and the ones that I think are useful at the bottom in the text beneath this video. But I am going to deal with 5 key areas, 5 critical areas that I think that you need to address, and hopefully this video will be a kind of an all-embracing video which will help you decide whether or not to go to court in the first instance, rather than necessarily drill into all the exhaustive detail of what is involved, which, as I say, can be found if you do your homework online. So I think really the first question that anybody is going to ask themselves is, how much is it going to cost me? Now, to give you the answer in a nutshell, before I go into the detail, if it's towards the upper end of the small claims track limit, 10,000, you should be ready to part with around about £1,000 if you lose your case. That's the financial risk to you. It's a little bit finger in the air, but actually not all that finger in the air. The blind share of that is going to be court fees, although be aware that there are fees. You or your opponent, if you win or lose, are entitled to charge fees for expenses, for loss of earnings from the day at court. Your witnesses are also, and if there's an expert involved, then as of today, which is 19th of October 2015, because don't forget the law changes, but this is the procedure as of today, up to £750 in respect of an expert, if an expert is required. So those are the costs at the upper end, if your claim is somewhere near £10,000. If it is at the lower end, then, I mean, you are talking about £100 in total is your entire exposure should you utilise the small claims track procedure. So that is costs. don't forget that there are some, the next thing to say is that there are some exceptions to bringing a claim through the small claims track. For example, personal injury claims, the threshold where there's an injury is a lot lower, it's £1,000. And where a tenant is bringing a claim against a landlord, for example, for repairs that should have been done, again, there are different rules. Also, don't forget that where the claim is non-monetary, I mean, the majority of claims will be monetary, but often they're not. It might be for an order of possession, for example, or a declaration from the court, or an order from the court in respect, say, of ownership, of registering your title on property deeds, or whatever it might be. Then the small claims track costs that I've described will not apply, or the small claims track will not be the appropriate forum for handling the claim. So just be aware of those exceptions. Again, it'll be laid out in the literature. You know, at risk of sounding like a crack record, you can find all this detail below. Be careful of the date of some of these websites. I noticed today, looking at Money Saving Expert, they made a minor error in court fees which changed recently. So there will be changes that you have to be aware of. For the uber geeks amongst you who want to use this opportunity to become lawyers themselves, then the Bible is the CPR, the Civil Procedure Rules. So for all of what I've said and all of what is said online on those information websites, the Citizens Advice Bureau and the Money Saving Expert, to the Ministry of Justice, is all drawn from the Bible, the Civil Procedure Rules, which can be found online. So you can always refer back to the Civil Procedure Rules. So, for example, today, researching the expert fee issue to make sure that I was on the money, I had to look at the Civil Procedure Rules, which have been recently amended, and I had to look at a practice direction. So ultimately, everything can be found in the Civil Procedure Rules. Right, so those are the exceptions. Now, I'm going to come on to, I've got some forms here, and the third thing I want to talk about is the protocol of bringing a claim. So it's all very well, being encouraged to use the small claims track procedure, but what's involved? Well, again, these sites will give you some detail, but I just want to flag up some critical things you should be aware of. Now, here is the form that you'll invariably use. It's the N1 form, can be downloaded as a PDF. Now, the important thing about this is to get your claim right. Now, when you draft the particulars of claim, or you can just use this box that's provided here, brief details of the claim. You can get more complex particulars of the claim here. You can add a sheet to this. Any important documents should be added to this. Let's say it's a consumer credit case, you might want to include the agreement you had with the bank in question. So that's how you will start your claim rolling. You'll have the issue fee, and for a £10,000 claim, it's over £400, 450 odd pounds. For a £300 claim, it's about £25, I think. Don't quote me on that. Just simply go to the relevant form, which is EX50, which is down below too. So the important thing about this claim form is to tell the story, and to try and not put your spin on it. Try not get too, what's the word? And it was disgraceful what they did, and it ruined my livelihood, and I had to, and at the time I was overseas, so there was an extra cost to me of doing X, Y, Z, blah, 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 blah. Try and say, I am John Smith. On the 5th of February 2015, I instructed a builder to do some works, number one. Number two, on the 1st of August to the 8th of August, the works were carried out by the builder. Give his name. You know what I mean? 3, I returned from holiday to discover that the the chest of drawers which I'd inherited from my grandfather that I value at £5,000 had been damaged by a piece of scaffolding. You know, I therefore claim, I believe that this was done during the time of those works. Nobody else was in the property during this period, and the builders had exclusive rights. So, you go through and you lay out the story, but lay out the facts, not the evidence. The evidence is for when you get to court, or when you produce, as you invariably will have to, a witness statement. So that's what you do, and I think this is critical because, and here's a very interesting point that none of the information websites that I've talked about or down below will tell you. For instance, and I speak from experience, and I'll tell you a little story. I had a client last year who was ripped off by a subprime lender, a non-status lender. She set up her own little business producing non-drip trays, and she was lent some money, and there was a very onerous redemption clause such that she was sort of trapped into the loan at a high interest rate. Now, she couldn't afford to pay me full time. She paid me for a bit of advice up front, and she decided to run the case. Good on her. However, she declined to let me get involved in helping her, or it's too expensive, with the, we're trying now to offer a small claim service at an economical price. I'll tell you about that at the end of the video. And she filled in this form. I saw it before it was sent off, and I said to her, look, you haven't laid out the claim accurately here. There's a danger that they could apply to have it struck out. So, if you bring a claim and it's improperly brought, because the same law applies for a multi-million claim as it does for a £10 claim, the law of the land applies equally to both. Even if the rules of court procedure are relaxed, they still apply. And she hadn't correctly particularised her claim on this form here. And the opponents, being a big company with deep pockets, could quite easily intimidate her and discourage her, and which they did by using the claim form, the poorly particularised claim form, as the reason. They brought us an application to strike out the claim. Now, there is, if you look at the boring old CPR rules, you'll find that there is a procedure by means of which an opponent can apply to have the other side's claim struck out for various reasons that I won't go into here. One is badly pleaded, no real reference to what the claim is. So they did that, and they won, and she was burdened with a large amount of costs. Now you may be saying, well, hang on, I thought the small claims track procedure was, because the claim was under 10 grand, the small claims track procedure was one that excluded lawyers, and where you didn't have to pay the other side's lawyers. Well, the thing is, you make a strikeout application before the claim is actually allocated to the small claims track. When you go to court, your claim will be classified into small claim, fast track, or multi in order of complexity. And where it's a small claim, sure, lawyers' costs are excluded, but until it's allocated, it's just a claim. So if a strikeout application is made at this earlier point, before it's been allocated to the small claims track, even though it's clearly under 10 grand value, you face this very significant risk of having costs. To keep it simple, be careful if you are bringing a claim against a large organisation and there's complexity, for example, a financial mis-selling claim, a loan, and she was actually as much a business as she was an individual, you probably do want some legal advice. So that's the, now at the other end of the spectrum, where you've got a really quite low value claim. I had someone approach me last week for some legal advice. They emailed me saying they had a dispute with their landlord who hadn't done some repairs. There'd been a leak from a tenant upstairs. The landlord was overseas and he wanted a little bit of help. I gave him as much as I could afford, a little bit of help for free, just quickly replying to the email, and I then guided him in the direction of the small claims track. And this is one of the reasons I'm producing this video, so that I can tell people who email me, look, go and have a look at my video first. So in that case, you know, my message to him was simple. It's such low value that there's no need to get lawyers involved. Just do your best. Fill in a N1 form, describe the events. You know, my landlord went away, the tenant upstairs had some works done, there were leaks through, and my floor was damaged, and here's the invoice which I paid to the floor repair company, you know, for £1,500 or £500 in this case. You know, put the claim in, attach the court fee, just to give you a flavour of what court fees are for bringing a claim, because a lot of claims are going to capitulate before you even, you know, before you get anywhere near a courtroom doors or a trial. Most opponents are going to capitulate because you're probably in the right. If you're serious and you actually bring a claim and spend money on bringing a claim. Here's the relevant page, and as you'll see, it's a sliding scale. So in the case of this chap, not greater than £500, he could have issued the claim for £70, filled in this quite simply, attached the invoice, posted it. You know, so on the other extreme, a very good, a simple system for relatively simple claims. Now, I just wanted to give you, just to really make sure you've understood this point, an example of another claim which may look as if it's a potential claim but it's not. Let's take the situation of repairs, or a builder this time who's done some damage. Let's say a builder had come into his flat and damaged the apartment whilst doing some works that our client had contracted the builder to do. Now let's just imagine that we're bringing the claim on behalf of the builder in this example, and we've done the work, it's cost £10,000 and the client hasn't paid, the builder's client hasn't paid. What happens in that situation? Well, you've got to be careful, because if you think there's likely to be a counterclaim, and let's say that during the course of the building renovations, the building works, you damaged a pipe which caused leakage, you know, if there is, and that leakage could have caused, who knows, a £10,000, £15,000 or even £5,000, but caused some damage, you've then got a counterclaim. And once again, a bit like the financial misselling claim, you're drifted into an area of complexity, and it's kind of best at least to get a little bit of legal advice or proper legal representation if you're going to bring that claim. So that's that. And I think, you know, I think the fourth point is legal advice. You know, when shouldn't you go for a lawyer? Well, I just wanted to explain that, you know, I've given you some illustrations of claims where you just simply shouldn't instruct a lawyer, where it's a very low value, and claims where you should probably get a little bit of legal advice en route. For example, in the case of the building claim, possible counterclaim, complexity there, financial misselling claim, she needed a bit of help with filling out the claim form, dangers there. Now, the question is then, well, where do you seek that help? Well, you can get it from me, and I'll charge you an arm and a leg for doing it. But I'll charge you, you know, my hourly rate is £300, so I'll charge you quite a lot of money. So if it's a £500 value claim, it's really not worthwhile instructing me. You should just listen to this video and do it yourself. You know, and bloody good on you. I think people should, at least once in their life, stand up for their rights and learn a bit about the justice system. See it as an experience. See it as a way of, learning a bit about being businesslike and defending your rights. At least once in a life you should do that. Now, there are other services out there that can help you. I've noticed, I think its website is smallclaimsolicitors.co.uk. I think there's a growth and a tendency towards, because access to justice has become more difficult in recent years for reasons of cost and other reasons. There are services out there who can basically give you, I use Geek Squad for my IT repairs, and I phone them up. They're very good, and they just fix my computer, and they go onto my computer remotely. They never visit me. So you can get a similar thing from the world. Now, don't quote me on small claim solicitors. I don't know them from Adam. Now, we are thinking about doing it ourselves, although we do tend to deal with more complex, higher value claims. But we are thinking about offering a service ourselves. And I guess that you're looking at, where a consumer just simply picks up a phone, an individual picks up a phone and says, I've got a claim, can I have an hour of your time? And we'll charge you £50 or £100 just for a phone call off the bat. You send in a particulars of claim because you want help. You want us to, let's say you fill in a particulars of claim and you want us to cast our eye over it. We'll happily do that. And for £100, let's say, an hour. So I'm thinking about offering that sort of service because I think it's an important service in the current climate. Because at any stage, you may just need that little injection of legal advice as you're continuing with your claim. You don't need me to turn up at court for half a day and charge you, £2,000. But you may want me on the phone £100 to talk to you the day before trial, or as I say, to look at a particular claim before you actually take out your checkbook or issue your claim online, which you can now do. You may want a little bit of legal advice before you take that step. So I think there's basically a need for a service where a low-cost, guidance, consultancy type advice service. Now, I think the Citizens Advice Bureau is good, but they're not lawyers, and they're a good first port of call, but I don't think they won't start giving you the help that you need in terms of the issues that I've just mentioned, court or filling in a claim form. Now, so I do think that there's value in judicious use of lawyers at key stages of your claim. Value of the claim accepted. If it's a low value claim, then just get on with it. Right, so that's it. I'm just going to have a quick look down my list to check that there's nothing I've missed. I wanted to conclude by saying that it works. I did it before I got into the law. I did my own small claim. I was making a short film actually, and I had an editor whom I'd lent £2,000 to so he could upgrade his editing suite, and he decided after he'd finished editing my short film, which had taken him longer than he'd anticipated, not to pay back my loan, and that hadn't been agreed. I went to court. The case will be referred, if it's not a company you're suing, the case will be referred to your opponent's local court, and so the case was referred to Norwich, and I did all the paperwork, and he didn't turn up, and I got judgment in my favour, and he was forced to pay me £2,000. Now I will just, so it works, but if there's anything any little tip or key sound bites that I can leave you with before we close today's video, it is paperwork and preparation. PP, paperwork and preparation. Before you issue proceedings, prepare your paperwork, okay? So, in the case of that gentleman who emailed me for some advice about claiming against his landlord for £500 worth of damages, I told him, write a letter to your landlord outlining your complaint, the cost, attach the invoice of the repair, and then since he was overseas, I recommended he take that letter to the estate agent who was managing the property on behalf of the overseas landlord, as well as send it to the overseas landlord, and just, you know, get the meat of the case in front of your opponent before you issue your claim. Make sure you have laid out what it is that you're complaining about quite clearly before you issue proceedings. Because opponents invariably will always say, I didn't get the claim form, I didn't know, it was served late, I never had a letter, he just went straight to court, da-di-da-di-da. One thing you can do, one good trick you can do, is actually fill out the claim form. This can fire a rocket up your opponent's backside if they're the sort of person who's put their head in their sand. Fill out the claim form, write your letter, and attach the claim form to the letter, so it shows how serious you are. So that's it, a whistle-stop tour around how to bring a claim yourself in the county court, in England and Wales at least. And it is the judge will take account of the fact that you're a litigant in person. The rules of procedure are relaxed, so if it does come to trial, and it at times will need that to make your opponent take, you know, your complaint seriously. If it does come to trial, don't worry, providing you've done the preparation and got your paperwork together, then just turning up will usually swing the whole thing in your favour. Now that's the video for claimants. I will in due course produce a video for those who are defending a claim that's brought against them and they can't afford instruction. But much of what I've said will cover defendants as well as claimants, but nevertheless I will be producing another video in due course. Thank you very much for tuning in this afternoon. Goodbye.